So I'm Mary Puzakowski. I'm the Assistant Director of the Online Graduate Programs at Albany Law School. Thank you for joining us tonight for our online lecture series. Every trimester, we do try to host 3 live lecture events based on our 3 concentration areas. Tonight, from our Health Law and Healthcare Compliance program, we have Professor Melissa Zambry. We are very lucky to have her as part of our Albany Law community, and we're fortunate to have her here tonight presenting an update on HIPAA. Before I turn it over to Melissa, I do ask if you please leave your questions until the end of the presentation. Please use the chat function to type your question in. That's enough for me. I'll turn it over to you now, Melissa.
Well, thank you, everyone, and thank you for being here, especially at this late hour. It's my pleasure to be here. It's my pleasure to teach in the program. And so tonight, I know it was tooled as a HIPAA update. I am going to talk about some updates in confidentiality in general because they are all interrelated. I know there probably are some people who have taken my class, so we'll provide an update to what you take. I know there are some people who may be taking the class in the future, and I know there are some people who are registered who work with the rules frequently. So we want to make sure we kind of cover all of those bases, and we'll go through just some basics. We'll go through what's happened over the last year or so, and then I am happy to take questions. Those of you who have taken my class know that I'm always happy to take questions and try to answer them. So for many of you, you are well aware that when we're talking about HIPAA, we're talking about the Health Insurance Portability and Accountability Act that did a lot of different things. It's a federal law. It had to do with both the portability of insurance and a lot of other different things. But when we think of HIPAA, we think of privacy. And that is generally what it has evolved to. The real basics of HIPAA was it was supposed to standardize electronic billing for claims. It used to be that if you participated with 20 or so different plans, you would have 20 or so different forms. And so this sought to standardize electronic billing. But when they saw that and they started to think about that, they said to themselves, well, what does that really mean? Is anyone protecting this information as we transmit it over the information superhighway? And what they learned was that some states, such as New York, did, and other states, we won't pick on any of them, did not. And so we ended up with 2 sets of regulations, the privacy regulations and the security regulations. And these apply to covered entities, which generally are most healthcare providers. There is probably a rural dentist somewhere in another part of the country that may not be covered because they are not conducting electronic transactions and they're not required to. But almost all providers are required to bill electronically now, particularly in the Medicare and Medicaid programs, health plans, your insurance plan, and clearinghouses, which help with billing. So the rules apply to those 3 entities. We'll talk about business associates where it extends to them, but it does not cover every employer or everyone who touches health information. It really just applies to those 3 different types of entities. When we talk about HIPAA privacy and when we talk about the updates, what you're going to see are some people who got in trouble for certain uses or disclosures of information because HIPAA requires us to only use information in a certain way. It requires us to keep it safe, to make sure that we don't inappropriately disclose it. It requires us to have certain administrative measures, like a privacy officer. You have to have written policies and procedures and other things. And people get certain rights regarding their protected health information. And we are going to see that some people have gotten into trouble for not granting those rights to individuals. Here in New York, we had a lot of these rights. They may not have been as spelled out as they are in the HIPAA laws, but we had some of these rights prior to HIPAA. So when we talk about covered entities and business associates, what are we talking about? Covered entities, as I mentioned, 3 required covered entities, and they are required to comply with all of the sets of rules and standards. They then, in certain instances, contract with business associates. And what business associates are persons or entities that provide certain services to a covered entity, and they are, in doing so, they have to have access to their protected health information. And so when we talk about these business associates, they are under contract with a covered entity, and they provide certain services. So for example, many accountants who service the healthcare industry are business associates. Many law firms, for those of you who are becoming lawyers, we are in many cases covered. When I represent a healthcare client and they show me either billings or they show me patient records because it's related to an audit, an investigation, defense of a claim, any of those types of things, I am required to sign a business associate agreement with them, and I am required to do certain things under that. One of the things is obviously I'm only going to use their protected health information to support whatever it is I'm doing for them. So I'm certainly going to take their information and use it for defense of their claim or whatever it is, but I'm not going to use it for my own personal purposes or anything beyond that. I'm going to safeguard it. I'm going to make sure that the people who work in my office understand how sensitive the information is. And if we improperly disclose it, if we email it out to the wrong person, if we do any of those types of things, I'm going to tell my client, which for those of you who are attorneys, that is not a good day when you have to tell your client that you've done something inappropriate with their confidential information, because they then in turn now have to do certain things. Business associates can be penalized by the Office of Civil Rights for violations under the HIPAA rules, and that becomes very important. When we talk about what's hot in the area of business associates over the last year, I would say there are 4 really kind of hot items right now. One of them is auditing rights. If you are a business associate and you've been a business associate since 2003 when the rules came to pass, you wouldn't have seen some of the things you're seeing now. What are some of the things you're seeing now? You are seeing covered entities sending you questionnaires, for example. Write down all of your policies and procedures or answer these questions in the affirmative. Do you have a policy and procedure that protects this, that, the other thing? What are your security standards? What type of safeguards do you have in place as far as your IT equipment? All of those things. And they are sending out these questionnaires and saying, if you want to do business with us, you are going to fill these out. And we have the right, because we've stuck it in the contract, not required under the contract, but we've stuck language in saying that we can do this. We can audit you. We can come in and look at your systems if we so choose. The idea of cooperation, and this can get kind of dicey. For those of you who are attorneys or going to be attorneys, you'll see it. There is language sometimes stuck in a business associate agreement by a covered entity that says, I'm going to cooperate. You're going to cooperate with me. We're going to cooperate with each other in the event there's a mistake or an investigation or that type of thing. And as you all know, sometimes that can lead to conflicts depending on who's blaming who for the bad thing that happened. So there's that language. Indemnity. You are indemnifying me for every mistake you make, business associate, related to my protected health information. How broad is that indemnity? And then quite frankly, many times if you have insurance that covers a claim that you breached someone's health information, many times insurance companies don't like you to sign indemnities because they don't like there to be something that thwarts their ability to defend you. So in many cyber policies, when you talk to your insurance companies, they'll say, we would prefer you business associate, not have an indemnity because we will be the judge of when we come in and defend or not or pay. And so those things working together and the language in business associate agreements, that has been a really hot area as to who's willing to agree to what and what should go in there besides the absolute required terms. And I would say that one of the things we've seen is that obviously depending on how much you want the contract, depending on your negotiating ability, those make a huge difference as to what that agreement ends up saying. So what about auditing and, the Office of Civil Rights? And the Office of Civil Rights enforces HIPAA, and they have responsibilities to enforce. They have the ability to audit, and they also are required to take complaints and investigate them. So what does that mean? What that means is enforcement over the last 1, 2, 3 years has been up. And some of that has been a criticism of the Office of Civil Rights early on, that they weren't penalizing people enough, that they were actually spending too much time helping people to comply with the rules and maybe not penalizing people, taking those penalties and setting an example. And after that report came out, as many of you know, once those reports come out, many times people shift. And so there was a shifting in the enforcement. And what you've seen over the last few years is more penalties and higher penalties. The idea being that HIPAA has been around for a long time and we should kind of have our act together. If we're going to do this, we should really have our act together at this point in the healthcare industry. So enforcement has been up, but auditing itself has been down. And some of that is just budget cuts in the Office of Civil Rights, where they have less money to work with. And quite frankly, they get so many complaints and they're required to investigate them. You only have so many resources. So while I would not, if you work at a healthcare agency, or for those of you, some of you on the phone I know work for government agencies, if I would not be running around telling staff, oh, don't worry, auditing is down, right? Because we don't want people not to take these rules seriously because, of course, enforcement is up. The idea that they are going to pick a point on the map and send people out there is probably not going to happen. State laws become very, very important as we talk about these rules, because some of the changes that you're seeing are actually in the state laws and how they interact with the HIPAA privacy rules, which, as you know, are federal laws. And so states such as New York are free to require additional protection, and they do. So in New York, we have our own HIV law. We've had that for a number of years. We have a different set of disclosure rules for mental health records, and alcohol and substance use records are actually covered by 42 CFR Part 2, which is a federal law, and that law has been in an absolute state of flux for the last year or two. Proposed changes, not all the changes, more proposed changes, and we're going to see in a minute that there's some proposed changes around right now. Why is there so much discussion around these? Obviously, these are sensitive topics, and they have sensitive information that belong to them. But some of what you're seeing in the healthcare industry is there is such a need now to provide quality mental health, quality substance use disorder services, and more of a composite of care, where we're looking at more of the complete person and we're not segregating mental health from alcohol and substance use, from somebody's traditional health. And there's an idea that we need to coordinate all of those services. Some of these laws, as you can imagine, are in place because of the sensitivity of the information. What I always tell people is, if my dental records got lost on the street, you would know that I'm a bad brusher. You would know that, that I have one cavity from when I was 10, even though I'm a bad brusher, so I'm super lucky. You would know that I go to the dentist 3 times a year instead of 2. But other than that, and the ability to perhaps steal my imprints and maybe take my identity, and if you do, you have to be in 3 different cities seeing clients this week, so let me know. But other than that, there's not much there. I'm not so concerned that you got my dental record. But obviously, someone's HIV status, or the fact that somebody's received mental health services, or the fact that somebody has received services for a substance use disorder, those are very sensitive topics and ramifications if the information gets out. Some of the debate over the last few years has been regarding whether or not there should really be a stigma attached to those types of records. And by treating them specially, do we encourage that stigma? And by treating them specially, do we prevent really giving someone quality care if we're really segmenting them that way? And so there's a lot of things going on, particularly here in New York right now, with behavioral healthcare collaboratives and people coming together to try to provide these services in a joint way. And a lot of people are saying, something, we need a little bit more freedom with disclosing these records. And that's some of the things that you've seen as far as some of the changes, and we'll talk about some of those in a minute. There has been some slight changes in how we define the penalties. No knowledge of the violation. Obviously, that's just someone made a mistake. We had no reason to think that we had to fix it. You see that it's a very small penalty. It gets more gradated as we go up and as they start to think you knew what you should have been doing and you just refused to correct it. And so most of the people that you see with heavy, heavy fines in HIPAA are people who have been before them prior. And many times they've been before them prior with the same issue. So they've come to, OCR has come to them and said, you have lost many laptops. Why do you keep losing laptops? And they say, we'll fix that. we're going to put better procedures in place, or we're going to encrypt them, we're going to take care of that. And then lo and behold, 6 months later, someone else has lost a laptop. So it is when you make that same mistake over and over again, or you're someone who's in front of them a lot, that they tend to lose their patience, and that's when you tend to see these bigger fines. There have been some very recent changes in the New York State General Business Law. This rule has been around for quite some time, but recently with the SHIELD Act, there's been some changes to it. And what it means for healthcare providers is that there is an extra kind of layer of what we need to do now. But here in New York, whenever private information was inappropriately disclosed that was held in some IT system, you actually had to notify the Attorney General's office. So there was one more notice that healthcare providers had to give if it involved these certain things. And credit or debit card numbers was one of them. You see now biometric information, a username and email address with a password that would access an online account. Those types of things, if those were lost in the course of losing, in many cases, other healthcare information, that became an issue. So the way it works now for healthcare providers, at least as we just saw this law very, very recently, is that if a breach is made under HIPAA, there doesn't necessarily have to be an additional notice sent to the individual. So you don't have to overwhelm the individual with notices, which is good because usually one notice for a person is far enough when they find out that you've breached their information. But you do have to notify the state attorney general, the Department of State. And so there are these additional information that has to be provided and these additional notices that have to be done. Very, very important that for those of you who have a breach notification policy, that it gets updated with this information so that the appropriate notices are done. So you have to comply with both, and you have to make sure that you're doing both. There's also a new DOH protocol that we'll talk about where they have offered the chance to individuals in the healthcare field whose data has been compromised, certain entities that they license to assist them. And so they have a letter, for those of you who have not had the opportunity to see it, it is definitely worth taking a look at, where the Department of Health has announced that they should be being informed when there is some significant cybersecurity incident, and maybe significant isn't even the right word. I think they would want to know, even if it's a little bit less than that. But at hospitals or nursing homes or DT&C centers, what you would call clinics, diagnostic and treatment centers licensed under Article 28, adult care facilities, home health agencies, LICSAs, as we call them, licensed home care services agencies, and those entities should be notifying them if there is a cybersecurity incident, and it defines what that incident is and what type of assistance that you want from them you provide and what else you are supposed to do. Notify law enforcement, notify, there's a poster that the DOH supplies, and making sure that there's appropriate notification so that a provider can get assistance. Here's, sometimes the issue with HIPAA in a very practical way. We like very much to hope these types of things are going to go away, or that it's a bad dream, particularly the cybersecurity stuff. And so we get, when we're in the industry and we're in the thick of things and someone loses something or someone hacks into a system, we want to hope that it wasn't serious. We want to hope that we get the information back. We want to hope that the person didn't look at anything confidential. And the truth of the matter is many times we can't prove necessarily that that happened, or we don't know where that thing is that got lost. And if we don't try by notifying certain people and try to do everything we can, sometimes we lose the opportunity to help. So I think it's hard because when we're in the situation, we all wish it would go away, but the truth of the matter is you need to act quickly. I mentioned 42 CFR Part 2, which covers, as I said, alcohol and substance use treatment records. In New York, these are entities that are licensed by OASIS, the Office of Alcoholism and Substance Abuse Services, and they are required to follow this very, very stringent additional law in 42 CFR Part 2. And we could do a whole presentation on some of the changes that are being proposed to 42 CFR Part 2. I have to say a lot of people would like these rules to go even further because of the opioid crisis, because of some of the things going on in the country. A lot of people think that these are very, very difficult rules to work with because they really do come back to consent of the patient very, very often. But you see some of the changes that they've made or some of the clarifications talking about certain orally conveyed information with non-Part 2 providers. That can be very confusing as to if I'm covered by Part 2, but I'm working with a provider that's not covered by Part 2, how does that work? Talking about consents, there's now a more general designation allowed on patient consents. It used to be, it had to be very, very specific who you were disclosing to and consenting to. They're trying to loosen that up a little bit. Clarification, there's rules about the redisclosure of Part 2 information. And what they're saying is that if it comes from an OASIS facility, that redisclosure rules, which are basically that you cannot redisclose it, still apply. But if it's not substance use disorder information, then that would be treated differently. Other things, there's rules about the prescription drug monitoring programs, because obviously, as you can imagine, to the extent that we have a national need to be monitoring certain drugs and their use, then that becomes important that they're able to get that information. There's inclusion now of natural and major disasters in emergencies when we allow someone to access the information, or what we call many times break the glass, what we call in New York when we're talking about accessing a record for an emergency or disaster. There's some information in there about research and how that works. Obviously, Part 2 records can be shared for audits and evaluations, and then, obviously in certain undercover situations. And so we're trying to find a way to make these rules work within the confines of what we have right now, which is an opioid crisis, which is a situation where we really need to get people treatment. And when we don't have laws that keep up with the times, that is when these laws become so difficult. And I think we found that in the healthcare industry because obviously the technology moves faster than the laws do, right? You stick a law in place in 2005 on security, and you never imagine that 10, 15 years from now, we're all going to be carrying the technology that we do right at our fingertips, or that patients are going to want to text us, or any of the number of things that are social media, which we'll talk about. So any of those things are new. And when you have a law that's old, and 42 CFR predates HIPAA, there have to be some updates, and we try to keep them moving. So what are the hot kind of penalties, if you will, that's happened? The failure to timely notify people after a breach. There used to be a little bit of leeway on this, because you are required to notify somebody within 60 days, but you're supposed to do it as soon as possible. You're not supposed to wait till day 59 just because you don't want the patient to call and yell at you. You're supposed to do it as quickly as possible, but you do have 60 days. And there used to be some leeway where maybe if you were a little late with that, maybe that would be okay. There's not as much leeway anymore, particularly if you're a provider that had already been late prior. So here you see a very significant penalty, really not that late. 60 days, an extra 45, it's really not that late. There's been a lot of notices that have been much later than that. But here it was time, they lost some surgery scheduling sheets. It wasn't the first time the provider was late with notices. But what gets very difficult here is, especially when we're talking about things that are lost, how long do you look for something? Because everybody likes to think that notebook, that bag, that laptop bag that had information in it, that it's going to be found. We all think it must be somewhere. We all think that folder has to be in the agency somewhere, and it probably should be. But at some point, we have to stop. I know hope springs eternal, but we have to stop with the hope for some period of time because we only have that 60 days, and we really need to get that notice in. Here's another one where there was a deferral of the notice, and there was a settlement here. And this is interesting because here you had a provider where there was unauthorized access, and the FBI actually opened an investigation. And so the FBI was investigating, and the provider just kind of, at the point the FBI opened the investigation, kind of sat on their hands and said, well, the FBI is looking into it. I'm not going to do anything. And then at some point, that investigation starts to resolve, and they provide the notice, and the notice is obviously late. And the company claimed the delay was because of that investigation. But the FBI never told them not to notify the individuals. And so the FBI kind of sold them out and said, we didn't tell you not to tell the people. And they end up in a situation where there's a settlement. There has been, in the past year or two, so many inappropriate disclosures of HIV information. It's so strange because for years and years and years, you didn't hear about this or the inappropriate disclosure of HIV information. Then all of a sudden, there's been a number of issues, including a hospital that agreed to pay a significant sum of money for disclosing two patients' records to their employers without consent. They were supposed to fax it one place, and they sent it another place, and all of a sudden the employer ended up with the information. And then many of you may know what happened to Aetna, but for those of you that don't, Aetna mailed thousands of letters that was a pharmacy benefit change, and they sent those letters out to 12,000 people, and the pharmacy benefit change was related to people's HIV status, so the cocktail of medication changed. The text was visible through that window, so you could see the person's name, but you could also see the suggested change of information, and therefore you would know that the person was HIV positive. That affected Aetna in numerous states. They were investigated by numerous agencies. They were sued in a number of jurisdictions, and that became an enormous issue for them. And, the hard thing with many of these HIPAA laws, there are certainly bad people who steal people's information and open credit cards. And that was really one of the first cases, was somebody who had stolen some credit card information from a cancer center in Seattle. And those things certainly happen, but most of the mistakes in HIPAA are it's accidental. People don't have any ill will. They're just, doing their jobs, and they don't do a very good job folding the letter in this case and sticking it in the envelope. Here you have a situation where a number of medical centers, very prominent medical centers in Massachusetts, invited some film crews on premises and to film a documentary. And the patients, they did not obtain the authorization from patients. And so a very significant fine there. This has actually been an issue in more than one place. There were it was an issue in New York City as well. And so that has been a hotbed at some of the more major medical centers. And then obviously, I can't stress on this enough, and I can't stress on it enough, not just when I give training to staff members. It's obviously very important when I give training to staff members, but it really is a great thing for everyone in their personal life. For those of you listening tonight, please remind your parents, anyone who uses the internet, your children if they're old enough. But this idea that the way people are getting into people's computer systems are to send links in emails, and you click on the link, and then all of a sudden you have given access to an entire computer system to people. It's called ransomware because in many cases, they actually do send you a ransom note. And I've always found this fascinating, and you can read about it. It's very fascinating. Most businesses in the United States actually pay the ransom, which I find to be fascinating because I'm 100% Italian, and I know that when I watch mafia movies and I drop $50,000 in cash on a corner somewhere because I'm trying to get my loved one back, my loved one is already dead. So I can't believe people pay the ransom, but guess what? Many times when you pay the ransom, you do get your records back, because if they don't give you your records back, then the next person's not going to pay the ransom. So it's a very, very strange system. You're not supposed to pay the ransom. You're supposed to call the FBI. But for all intents purposes, what you really can't do is click on the link. And for those of you who are at agencies or healthcare agencies or healthcare providers or facilities. If you haven't sent out a fake email out of your IT department trying to get your employees to click on the link and then provided some instructions as to how they should have known that they shouldn't have clicked on the link, it's a very, very useful thing to do. It's something we've done at our law firm. And you would be surprised, particularly with the speed that we move. So one of the things that I would say about HIPAA, and I would offer to anyone who asked, is I think one of the hardest parts with HIPAA is that we tend to move so very fast as a society. 15 or 20 years ago, we didn't have right now, I'm not looking at my phone, but it's next to me, right? So there's stuff going on my phone right now. Obviously, there's stuff going on the screen. All of those types of things. We didn't have so many distractions, and we do now. So when HIPAA mistakes happen, many of the times it's just because people are, they're moving too fast. And you get that email, and the email says something like if, for example, in one of the cases that we had, we sent around a fake email that said, your mailbox is almost full. Well, that just strikes fear into the hearts of lawyers, right? Because they're going to get a document and they're not going to get it, and it's going to get bounced back to their client. And so it was like, your mailbox is blue, you need to click on this link. And a lot of people, there were people on vacation or people walking down the street to a meeting who panicked and clicked on the link. So this is so important. It seems so simple to follow, but it is such a major, major, major deal right now. And certainly something that we all need to get better at, because it is the way. They have frozen records of hospitals that have had to go back to paper. They have frozen, records at all different types of organizations. And then there's social media. And there have been so many cases of social media and mishaps, and I get calls on a weekly basis about it sometimes. And, it's just that obviously social media was not in play when HIPAA came out. There was not this idea that we would be putting up posts or posting things or posting pictures the way that we do now. Obviously, I'm from a generation that once knew life without social media. We have generations now that are never going to know a life without social media. And we're very, very used to sharing on a widespread basis in a way that we never did before. I remember when I was a kid and I was playing softball, there was a huge debate in my town about whether or not you should put kids' names on the back of jerseys, because wasn't that private information? And then people who, had ill intent would, call you over for candy or to find a lost puppy, and they would know your name, and then bad things would happen. Now everybody puts up pictures of their kids, and then people share it, and we think nothing of it. And the problem is social media, when it mixes with healthcare and when it mixes in the workspace, it can be very, very bad. And again, usually it's just people who aren't thinking. So I get a lot of questions about it, right? I get people who post, kind of this verbal gossip, and they don't name the person, but it's enough information that people they work with, or quite frankly, sometimes the individual themselves recognizes themselves. And that can be an absolute disaster. And I'll talk about some specifics that have happened recently to talk about. But the idea of sharing of photographs, right, in any form, no matter how cute they are, sharing, putting up photos, with you and a patient, or, you and somebody, the individual, somebody that is served by the agency or wherever you work, without consent. And that doesn't mean that, obviously your development people can get consent and then send out those nice development packets to try to raise money, but you need consent for that. And so, but so a lot of times when we see a picture now, particularly people who use social media, they see a picture, all they can think of is it postable? Should I put this up? And so I think staff members get very, very careless with that sometimes, and we end up in situations. There's a lot of times that people who are not familiar with how social media works, they think something is private. They think, they deleted it, so therefore it must be gone. And the truth is, we all know that, your friends see it, but then if they comment on it, their friends see it, and it's a lot more viral than we often give it credit for. So, and then, I have gotten this call a number of times, people taking pictures of their desk, taking pictures of their office, and then posting them and saying, in one case, look how freaking busy I am. And the person's desk was very, very busy. But the problem is when you blew up the desk, you could see charts. And if I was on, CSI and I had a super duper camera that could really blow things up, I could probably read the charts. And so that becomes very, very difficult. And of course, by the time the agency figured out that it was posted, it already had 36 likes. So you knew that people had seen it. So, we see these are real examples. A paramedic posts information on social media about a sexual assault victim, and that allowed the media to figure out the identity of the victim and where she lived. So something that was supposed to be very, very private, something that we would want as a society, quite frankly, to not disclose, was now out there. Temporary employees posting photos of medical records and putting them up on social media, and you can see all the information about the person. A nurse posts on social media about an alleged cop killer, as she called the person on social media that she had treated. Now, she doesn't discuss the details of his condition or any other identifying information, but that one detail, you would hope in any given day in any given town that there's only, one cop shooting that you've seen, or one police officer shooting. So you hope, obviously, that that's the only one. And so by doing that, she disclosed information about that individual without even ever saying the person's name, but that's enough to get anyone in a certain town to know. A nurse posted a picture of a suicidal patient on Facebook. The person died soon after the photo was taken, and it was from a suspected attack. And it was a homicide. So we'll never know if that nurse posting that picture led to the attack, was related to the attack, and now that nurse has to live with that. And you can all imagine this: an employee of a gynecologist vents online, making fun of patients giving birth. She was obviously a little sick of pregnant people and dealing with them. And she didn't use any patient names either, but two of the patients recognized themselves from the details provided. So not only is it a HIPAA concern, but it's also a patient relationship concern. And you can imagine those people were very, very, very angry at the physician. Here is an Allergy Associates, you can imagine this happening. So a physician, a television station talks to a patient. The television station, then there's a dispute, and they call the doctor, right? So now the patient has complained about the doctor. So the news calls up the doctor and says, hey, here's what this patient had to say about you, blah, 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 blah. And then the doctor says, oh, yes, you want to know something? I'll tell you what the truth is about that patient, and goes on and on and on, defending themselves. But in doing so, gives out all of this information that's protected about the patient. I think we all know people who would respond the same way to that type of call. So you can see these things happening. This is very, very recent that this has been settled. It was obviously from quite some time ago, but this was one of the most recent OCR issues that came out in a press release. A complaint alleging that Elite, this entity Elite, had responded to social media review by disclosing the patient's last name and the details of their health condition. And then in response to that, obviously they take a good hard look, and what they find was that indeed the person in their response to the Yelp review, the physician or whoever worked at the physician's office, had disclosed information about the person to respond to that. And for any of you who know somebody who's in a business that is subject to Yelp reviews, they can be very disturbing, because most people they don't put up things on Yelp all the time when they're happy with the meal, or when they're happy with their haircut, or when they're happy with the service, which we all should do more of, right? We all should actually do more of that. But what they do, right, is they put up something where they are not happy. And the problem is if you are in a physician's position, there is not much you can say to defend yourself on social media Really, quite frankly, you could argue, depending on the type of service, that you getting, you responding to it in many ways is somewhat disclosing protected health information. And so you got to be really, really careful responding to online reviews, no matter how awful that they are. I do have one friend who's in a business who has subject to online reviews, and one of their methodologies is they have all of their really, really good clients put up a review after a bad review, because eventually it goes really, really low on the list of Yelp and you don't see it right away. But responding to those in any sort of negative way or in a way that discloses information about a patient is just very, very dangerous for a healthcare provider. Here, all I will say here is that when an employee is terminated from an organization, and I would say any organization, it doesn't have to be a healthcare organization, but removing their access to the computer system, to the IT system, to any web-based applications becomes very, very important. And I can tell you in a number of cases in the healthcare industry, people have gone on and wreaked havoc in a system where they were terminated, they were unhappy with their termination, and they went in and they looked at, the CEO's health records, or they printed stuff off to defend themselves, or they printed stuff off and threatened people with it, or all types of things. And so very, very important that when you look at your former employees that you really get that right. Here you have a corrective action plan, and this is related to, and I talked about the access rights, one of the rights of patients. There are many rights of patients under HIPAA. There is access, there's amendment, those types of things. But access has been very important. And here you see one of the first settlements that comes from someone not providing timely access to records, in this case about an unborn child. And that becomes very, very important. And access questions are not always simple. I mean, sometimes it's very simple, right? Because somebody wants access to their record, they're going to a new doctor, you send it over, it's really not a big deal. But many times, sometimes there are sensitive issues where healthcare providers do take a moment to think about providing access. Many times when a patient is deceased, you have to think really hard about access. I had one client who was a mental health provider, and they had a situation where the mother was the lawful heir and would have had rights to the file, but your HIPAA rights extend beyond your death. And one of the things allowed by HIPAA is for you to restrict access. And the person, while they were alive, said, "You are never to release any of this information to my mother." And so that was one where if the provider hadn't stopped and thought about it, they might have made the wrong decision. So it's fine to stop and think about it. And particularly, many providers, when they get those requests, they think, oh my goodness, am I being sued? And is there something I should think about there? It's fine to call your lawyer, but you can't let a long time go. You have to provide those records. Access is actually shorter here in New York. If it's a lot of copying, then maybe you get longer than the 10 days, but you're supposed to be able to give someone access within 10 days here in New York. HIPAA, you have 30, and you can get an extra 30 extension, but you really need to get those records over to people. Talked a little about hacking, but here situation where a compromised ID and password, and now all of a sudden 3.5 million people's records are out. And the problem here sometimes is not the idea that you were hacked. There's a little bit of a feeling that anyone could be hacked. The issue is when OCR comes in, the Office of Civil Rights comes in, and they ask you, what did you do as far as a risk analysis? What did you do to try to prevent a hack? What is your process to review your firewall, your policies and procedures? And if they come in and they found out that you didn't really look at these things, you didn't analyze your potential risks, your vulnerability, that's when they start to think, something, this really is your fault. I think they truly understand that anyone can get hacked. It's what did you do in preparation to try to make sure that that didn't lead to bad things for your patients. And if you can show them you did something, many times you're not in the situation where they're penalizing you. If it looks like you didn't do enough, or you turned a blind eye to it, or it seemed overwhelming, so you never got to it, that's when bad things happen. So you see that in 2018, they settled 10 cases and secured a judgment, 28.7 million. That surpassed their previous record. They did have the largest settlement in history with Anthem. Poor Anthem. That was just a disaster. But they had a banner year, and obviously banner years are good for OCR, particularly after the criticism. So you can expect that you will see more penalties as you go. So, what should covered entities do? Well, obviously internal auditing, making sure policies and procedures are updated. You want to be able to say what you did. What did you do to try to comply with these myriad of rules? They know the technology changes. They know it's a difficult landscape. They know all that. But if you can show efforts, and you can show that when someone got in trouble for something, you tried to see if you were good or bad at that topic, and then you tried to make changes, that's very, very helpful. Obviously, any efforts that you make towards compliance, you want to document, because they will ask what you did. You need to coordinate privacy, security staff, IT, HR needs to be involved in this, right? Because HR terminates people and then IT needs to know that they're terminated, or sometimes there's a privacy or security violation and we need to figure out if somebody's going to be disciplined. There needs to be coordination between the compliance, the IT, and the HR to really get this right. Obviously, they'll ask for what steps you're taking. I always tell clients, do the easy stuff and document it. Some of it's going to be expensive and all of those things, and you figure out where you spend your resources. There's only so much money in healthcare, but really, some of the things that lead to HIPAA violations are very simple. It requires training. It requires reminding people. It requires making sure that people understand the gravity of situations and notify you. And then obviously, cyber liability insurance, much more all the rage over the last, I'd say 3 to 5 years. It used to be a very hard thing to buy. People didn't really know how to price it, but I'd say now much more common. Obviously, it's created to protect against losses from hacking. Some providers do have some coverage for breach of confidentiality under their negligence policy. But cyber liability, a much broader protection, really talks about the security stuff in many cases, and obviously gives you a little bit more of an umbrella, gives you those defense costs. But privacy lawsuits, and what I think everybody should understand is that in New York, privacy lawsuits are not sued under HIPAA per se. Right now, there is no private right of action under HIPAA. There are people who think that should change, but there is no private right of action under HIPAA. You are sued under a negligence theory, straight negligence, a breach of a duty to keep something confidential. I confided in you. You had a duty to keep it confidential. You did something wrong that deviated from the standard of care, and the standard of care in the industry is HIPAA, right? And then you caused me damages, and here's what my damages are. And that is and this existed before HIPAA, but how HIPAA changes that is it's changed what the floor is. What the floor is what people are doing about HIPAA. It is senior leadership that is important in your organization. It takes one person at the top of an organization to say, this is a bunch of bunk, this is silly, this isn't necessary, and everyone will follow suit. So it really has to be tone at the top. That's where the culture comes from. It comes from boards. It comes from managers. It comes from supervisors. It comes from the CEO. And here you see 3 cases, big companies, obviously, Wyndham, Target, Home Depot, all with significant cybersecurity breaches, all of them dismissed or with favorable decisions because they discussed in the board meetings cybersecurity. They had audit committees, and I should say each of these boards each of these boards were sued. And so they sued these boards, and every one of them ended up in a favorable situation because they tried. They tried. The board talked about it. They got consultants to talk about it. They talked about it at meetings. They met. They talked about how hard it is to comply. They tried. They put resources to it. And you know something, they were still breached, but they tried. And so that becomes very, very important for boards of directors, for management, for CEOs, for CFOs, for chief information officers. What have you done to try? Email tips, I always go over them because they're just so important, because email, we let so much information go through email. You should not be spending protected health information that is not encrypted. But email in general, must you reply to all? What are you talking about? We've all seen errant emails go to the wrong place. You got to be very, very careful. Be aware of the group, right? You know, we have group firm all. Okay, that's a lot of people, right? Group firm all. Want to go to lunch? I'd love to go to lunch with you, but you're in Buffalo. I'm in Albany. You have to contact me at 7 a.m. next time you want me to go to lunch, because I got to get driving, all right? So being careful with those groups, which are wonderful, except when you hit the wrong group. Checking what's at the bottom of the chain. I've had numerous providers with this problem. It happens all the time. They're talking about a patient, back and forth, two people working in the organization, talking about a patient, and then all of a sudden they go, want to go to lunch? Oh, because it's 11:59, we need to go to lunch. Where do you want to go to lunch? Let's go to Panera. Hey, you know who should come to Panera with us? Cindy. Remember when Cindy worked here? She was so much fun, but now she works somewhere else. Copy Cindy. Now Cindy has all the information, all the protected health information that was in that chain. So all of a sudden, it's like you just wanted soup and that like loaf of bread thing they give you. And now what have you got? You've got a breach at 11:59. By now it's noon. And your day is not nearly the pleasant day that you thought it was. Writing for publication, I know, right? For those of you who are lawyers on the phone, you know what this means. But, you know, anything could be the exhibit of a lawsuit. Anything could be read by people that you didn't think were going to read it. You know, making sure that you say what you really want to say and that you don't say things that you shouldn't say. Does it have to be in writing? You know, we really don't like to talk anymore. I know we don't like to talk to each other. We don't like to talk on the phone. We would rather text. But sometimes if we're talking about patients, or we're complaining about, quite frankly, anything, or we're talking about our fellow employees and the mistakes that they made, that may be the time to pick up the phone and not send that email. And obviously, we tell, you know, board members and others, if we send you privileged communication, you don't want to send that too far, because you don't want to forward on information that actually leads to a concern about privilege. So, you know, some of the things over the last year, I would say, is taking a look at what your employees agree to. What does it do extending beyond their employment? Do they have to return any protected health information they have? Are they not allowed to take that with them? Where does it say that, so that when they leave and we think they have protected health information, we can send that, you know, letter? Social media, obviously. A device policy. Some places give you the device. Some people are using their own device. What does that mean? What are the rules if you're using your own device and there's protected health information on it? Bringing protected health information out of the office. What are the rules about that? There was a home care company not too long ago that was fined because a home care worker went home after her last visit. She brought in the records from her car, which is a good idea because records get stolen out of the car all the time. She put them on her kitchen table. Her estranged husband came to pick up the kids. She went to pack up the kids. The estranged husband understood HIPAA. He rummaged through the records and he blew her in. So the home care company said, I can't believe you're going to fine us for this. This guy's a bad guy. Like, come on, give us a break. And they said, where's your policy about what people should do with records when they take them home? So there you go. Using a home computer, nobody should ever be doing it. If there's PHI, you should not be sending PHI to a home email, a Gmail account. That should never happen. I think we all know that our computers at work or at school are, you know, protected. I think we all know that our computers at home have maybe scary stuff residing on them, or perhaps, you know, our children use them and we don't know what links they're clicking on. So we got to be very, very careful with things like that. And then the idea of ex-employees. You know, a lot of times, particularly in healthcare providers where they serve people for a long period of time, it becomes very, very difficult sometimes to divorce yourself entirely from those people that you serve, and you're curious to know how they're doing. And the truth of the matter is once you're not employed anywhere there anymore, you don't have a need to know. And that's very difficult sometimes. But your employees should understand they really shouldn't be talking about people with people who don't have a need to know anymore. Policies and procedures need to be updated. If you have policies and procedures that are in an old font that we don't use anymore, that's when you need, even if you just retype them in a good font, you really, really need to update those to make sure that they're not old and stale. Minimum necessary, we've talked about. Training should be updated. I often say to providers, if your HIPAA training, still has kind of clothes from like 2003, it might be time to just, update it a little bit. If it doesn't talk about social media or your, iPhone or whatever, it probably needs to be updated. If you have a board of directors, they should be informed, they should be trained, they should know enough, as I always say, to have a discussion at a cocktail party about hot topics in healthcare. This is one of them. We talked about photos. Development office should be trained, right? They got to have consent. A lot of debate about how old your consent to use pictures is. I've seen some development offices get in trouble sometimes because they use a consent that's really old. When they got the consent, the family was very happy with the agency. Now, years later, they're not. They put a picture of the person in, the development office's little brochure that goes out, and the family says, who gave you consent to use that picture? And now you've got a consent that's in an old font, and it's really old because you've been serving the person for a long time. Just things to think about. And obviously an HIV policy, making sure you have it, making sure it's updated. And actually that is required to be reviewed annually here in New York. And that is most of my time, but I am certainly happy to take questions if there are questions. And if you think of a question later, or you have a question that you don't want to ask on something that's being recorded, which I certainly understand, you all have access to my email, and you are welcome to ask me a question anytime. I am always more than happy to answer questions. But if I get questions, I'm happy to answer them. If not, I want to thank Albany Law School. It is my alma mater. I am so privileged to teach there, and I am certainly privileged to still be affiliated, and I have nothing but fond things to say about it. And so I want to thank them for having me tonight, and thank them for allowing me to teach there, and I want to thank you all for participating. Thank you.
Thank you so much, Melissa. Just wanted to ask again if anyone has any more questions. Otherwise, I do want to also thank everyone for joining us tonight. Again, we welcome any feedback. If you would like to chat to me about our programs, or if you'd like to talk to me about Melissa's upcoming class in January, now spring 1 term, please feel free to give me an email or call me. My email is graduateadmissions@albanylaw.edu. We are also hosting one more live online session for this trimester. It's on blockchain and cryptocurrency. Again, email me at graduateadmissions@albanylaw.edu if you'd like information for that. So again, I'm Mary Plizakowski. Thank you so much, Professor Melissa Zambry. Have a great night, everyone.